Good to have you with us, sir.
Thank you, Your Honor. May it please the court, I'm Richard Krautharmel. I'm from Raleigh, North Carolina. I represent defendant appellant David Orozco. I would like to reserve 5 minutes for rebuttal.
Yes, sir.
This is a search warrant case from the Eastern District of North Carolina. More specifically, the issue is whether or not the search warrant that issued in this case had or lacked probable cause to search the electronic media that was found on Mr. Orozco's person when he was arrested for having no operator's license. The facts are fairly simple. An officer was sitting in his patrol car in a small town in North Carolina checking license plates as they drove by. He noticed Mr. Orozco's plate, and he looked on his computer and found that the registered owner of that vehicle did not have a driver's license, so he pulled out and followed him. He observed some traffic violations, and so he put on his blue lights and he stopped him. He discovered that Mr. Orozco was not the registered owner of the car, but had borrowed it or rented it, I can't remember which. But Mr. Orozco did not have a driver's license, and most importantly, he noted that Mr. Orozco was nervous, in his opinion, that there appeared to be scratch marks on the dash of the car, which indicated to the officer in his training and experience that something might have been hidden behind that dash. So he called for the drug detection dog to come to the scene. Another officer arrived to help him. That officer purportedly questioned Mr. Orozco, who gave permission to search the car. The drug detection dog alerted on the car, and the officers then pried open that dash, and they found $111,000 plus hidden behind the dash. They subsequently had the drug detection dog walk past that cache as compared to other cache they had on hand, and the drug detection dog alerted on the cache they found in Mr. Orozco's car. So they suspected that Mr. Orozco may be involved in the drug trafficking business, so they sought a search warrant to search his car.
Just so that I'm clear, at this point, because I think you're now getting ready to get to the part that you disagree with, at this point, they had probable cause to do that search and to locate the cache. Your question is, what do they have past that, right?
Correct.
Okay.
So they seek a search warrant, and that search warrant is located in the joint appendix starting on page 39 through page 43. And they asked to search the car, because it had the cache in it, a Samsung cell phone that Mr. Orozco had in his possession. And then lastly, it says...
Is that the same phone that had the GPS data on it that he closed down as soon as they got there?
Yes, Your Honor. There was a flip phone and a Samsung smartphone. It was a Samsung smartphone that he was using while he was driving, navigating with a GPS app, and closed down when the officer stopped him. And then a flip phone, and then some micro SD or secure digital cards that they didn't know about until they got him down to the police station. But so they get him down to the police station, they're searching him, and a $100 bill that's folded up falls out of his clothing.
You're talking about after the warrant was issued now?
No, they haven't gotten...
You're still before the warrant?
Yeah, we're still before the warrant. So when they're searching him down at the police station, this $100 bill drops out, it's folded up. Inside of it are these micro SD cards. And Mr. Orozco immediately, they unfold the $100 bill, the SD cards fall to the floor. Mr. Orozco immediately picks up a couple of them and puts them in his mouth and starts chewing. They stop him, they get those out of his mouth. One of them is destroyed, I think. The other one's partially destroyed. But they gather up all the evidence, and then they go seek a search warrant where they ask to search the car, this cell phone, and these micro SD cards.
Well, counsel, are you drawing a distinction then between the basis for searching the cell phone and the basis for searching the memory cards, the SD cards?
Yes, Your Honor.
You're not taking any issue that once somebody puts those items in his mouth, that's a highly suspicious circumstance, given the fact that there was $111,000 found on him, that the police had a reason to believe that something was going on.
I agree that's suspicious behavior.
Okay, so it's only the cell phone that you're complaining about here?
Well, no, I'm complaining about both, but for different reasons. So they get this warrant, and in the warrant
You say there wasn't probable cause for either one.
Correct, that's my argument.
The warrant doesn't have it's not supported by probable cause.
Right, for both.
But it's the same reason then. There's a lack of probable cause. is what you're
In
saying.
general, yes. The ultimate argument is that the warrant lacks probable cause for both the phone and the SD cards.
But these officers were doing things just the way they're supposed to do it. I mean, they got the information and then they went and got a warrant. We criticize them for doing warrantless searches all the time.
Right.
And we like for them to go see a judicial officer and try to get a warrant. And that's what they did here.
Correct.
Now you're still complaining.
But they can't hand wave the warrant requirement. They can't just kind of shuffle their way through it. They still got to meet certain requirements to get that.
Warrant has to be supported by probable cause.
Correct. And so I'm arguing that it is not supported by probable cause as to that cell phone and those micro SD cards. And with respect to the SD,
After he tried to eat one of the cards, or more than one.
well, the problem is with respect to the search warrants have to answer two W questions. The first is what? What do you want to search? The second is why. Not why do you want to search it. The magistrate knows they want to look for evidence of crimes, but why do you think that particular thing or place has evidence of a crime? With respect to the micro SD cards, the search warrant application satisfies the first question, what? I want to search the micro SD cards, but it never satisfies the second question, the why. Why do you think it contains evidence of a crime? And like I said, that's on pages 39 to 43 of the joint appendix, but never in this application does the officer write the magic incantation, in my training and experience, drug dealers keep evidence of their crimes on their micro SD cards or on their electronic media in general. And it
Okay,
doesn't
to what
really-
extent, though, counsel, can we consider the fact that this warrant was obtained after the defendant was found driving somebody else's car? He said he was only driving the car because he was paid to do so. Isn't that correct?
Correct.
And $111,000 was found hidden in the car.
Right.
And the drug dog had detected or had alerted on the car itself. So don't we have to consider all of those facts? And so you're just saying that it's a leap to
Yes, Your Honor.
include the phone. To what extent does common sense and common experience play in? You're saying that there have to be essentially magic words in the warrant.
Well, the
that,
government argues about this term of reasonable inference. The magistrate's
Mm-hmm.
allowed to draw reasonable inferences based on what they do tell him. And you have the Williams case out there, which talks about a house and basically says it's reasonable to infer that if somebody is believed to be involved in the drug trade, they're probably storing evidence of their drug crimes back at their house. So a warrant can issue to go search their house. And so the question is well, should that extend to something like a cell phone? Is it reasonable to infer that perhaps they're storing evidence of their crimes on a cell phone?
Help me understand this. So, I mean, I understand this idea about a reasonable inference, right? But they pull up to the guy. He has the Galaxy open. It has a GPS indicating he's going somewhere, right? And then he tells them, I got paid to deliver this car. Well, the GPS, which is on the phone, and the evidence of the GPS, where he was going, is on the phone. He's told him he's driving a car that's not his with $111,000 cash because he was paid to do so. Why isn't that like the most direct evidence of drug trafficking?
Because it's not illegal to drive a car filled with cash, even if it's hidden.
Yeah, but there's probable cause to believe that was drug money. I mean, that's where we started, right? Because I asked you at the beginning, you agree there was probable cause to search for the cash. And then when they find the cash, maybe it's not proof beyond a reasonable doubt, but there's probable cause to believe at that point that that's drug money.
Well, I don't necessarily agree with that. Your Honor.
Okay. Posit for a minute, hypothetically, that there's probable cause to believe the $111,000 in cash is drug money. And posit, except this is a hypothetical, that your client said he got paid to drive that in a car that wasn't his, and posit that the officer saw when he walked up, there was a GPS, open on the phone that he immediately closed. So if those facts accept those facts, like why isn't that probable cause that the location where he's going, which was on the GPS, is evidence of his involvement in drug trafficking?
Because he doesn't write it in the warrant and say, in my training experience, drug traffickers will keep evidence of their crimes on their phones. And that's not, I would argue
No,
that's
no,
not necessarily a
but
given.
he doesn't have to write that, because what he said was, what is in the warrant is that, like, it had the GPS data. I mean, it showed that he was there, right?
But he doesn't link it in the warrant. He doesn't say, and I'm not so sure, did he?
I mean, maybe he doesn't. I mean, maybe that's my rub. Does he include the GPS data? Maybe I'm overstating the story
And
here.
the affidavit is insufficient. Is that what you're arguing?
Correct.
So you're talking about the warrant, but you're really talking about the affidavit,
The affidavit or the application for the warrant.
what to support the warrant.
Correct.
You're saying that this stuff wasn't sufficiently written down,
Correct. And so,
and the judge didn't know enough.
right, he doesn't have enough facts before him to
They
know.
deceived the judge, even though they knew enough, as Judge Richardson laid it out there. You're saying they didn't write enough of it down to properly convince a reasonable judge.
Right, because if we just allow them to write conclusory language in an application and have the magistrate just rubber stamp that, then we're not really going through the warrant process. We're not asking a disinterested neutral observer to look at the facts and decide if a warrant should issue. And that's what's in this affidavit, is conclusory language. In my training experience, all of these facts amount to, and he writes, probable cause to search a Samsung phone located on a Roscoe.
Would the affidavit have been sufficient if it had linked the phone and the SD cards as being compatible?
Right. I do think that would have helped. That's not alleged in the application. They don't say these SD cards.
You're
are-
saying that's the kind of missing link that we didn't
Right.
have in this
There's
case.
that. There's the fact that it's not necessarily illegal to drive around cash. I mean, I know a guy who, when he walks the city, he has $100 in cash on him, he sticks 80 of it in his sock, he puts the other 20 back in his wallet, and it's for the specific purpose that if he gets mugged, all the robber gets away with is $20 and not the full $100. So sometimes people hide cash, so they don't want to lose it.
But so I'm going back to the J, because I said something, you questioned it, and I want to come back to it. He talks about the GPS phone being open on page 41 of the JA.
Okay.
Right? This is the affidavit where he walks through this information, right? And so if, and I'll let you just accept hypothetically, there's probable cause to believe that he's engaged in drug trafficking by moving drug money, and that's hypothetical to you, I understand you don't accept that, then why isn't where he's going with the drug money evidence that you have probable cause for? Accepting my hypothetical that there was probable cause to believe that he was engaged in drug trafficking once they found the $111,000 hidden behind the dashboard that the drug dog alerted on.
So, I mean, that, admittedly, my argument on the phone is weaker than my argument as to the SD cards regarding the allegations in the affidavit or the application. But even if the court says, no, we think there's enough in this application to support a search of the cell phone, you still have the problem with the micro SD cards.
All right, so can you talk to me about, Judge Traxler had an opinion maybe a year or two ago called Cobb. I'm not sure if you're familiar with it. This is one where the guy gets arrested for murder, and from the jail he calls his father or somebody and says, hey, like, get that laptop out of my room, you got to wipe it. And Judge Traxler says, yeah, there's obviously probable cause to believe that whatever's on that the defendant is saying, get the phone, get the computer. It's a computer, not an SD card, but a computer, because it's got, some stuff, using a slightly different word, on it. It need to wipe it, but not saying what or connecting it to anything. And Judge Traxler found that was probable cause to believe that it was evidence of the murder. Turned out not to be. It turned out to be the same kind of information we've got here. But how is this case different? I mean, he's chewing them up, right? He put, in his mouth and chewed them up.
It's suspicious, but the officer never discusses it in the application. He just starts off saying, I want to search those SD cards.
He puts a lot of other stuff in the application. About the hidden compartment,
Right.
he made a spontaneous utterance that the money wasn't his, that he was paid a sum of money to transport the money, but he wouldn't say how much money he was paid.
Well,
And went on, in the drugs, in a hidden compartment found in the car, there was a hidden compartment in the car. Well, that's what they haul money and drugs in hidden compartments. And he talked about his experience, hidden compartment in the car. And that's where they found money in separate plastic grocery bags. I mean, they spell out a lot of stuff in here.
Yes, I understand that.
And he says, he represents to the magistrate, that's enough and based on my experience to be probable cause.
To search the car.
And then it was up to the magistrate judge to decide whether there was probable cause for the warrant.
Correct.
And the magistrate said yes.
Right.
And you're saying that's a violation of the Fourth Amendment?
With respect to the micro SD cards, for sure, and with respect to the cell phone.
But he says on page 43 of the JA, and then I'll let you sit down. I know we're over. But he says he put them in his mouth and tried to chew them up. I mean, what I was trying to ask is, why is that different from Cobb? When you say, hey, wipe my computer, right? And then shoving them in your mouth and chewing them up.
Admittedly, there's a lot of case law out there that says attempts to secrete something might be somebody trying to hide evidence of a crime, and a magistrate can draw a reasonable inference to that effect. But in this case, it could be anything. It could be something else that he doesn't want the law enforcement to know about necessarily.
What about the fact he had been storing these cards in his shoe? People don't usually, I mean, that's kind of unusual behavior, isn't it? Right. So you start with someone storing these memory cards in his shoe, and then he puts a couple of them in his mouth. I mean, that suggests destruction of evidence, it seems to me. What other inference could the officer possibly have drawn from the fact that he was trying to chew and swallow these cards?
I mean, if you go back to my example about the guy who hides the money on his person so he doesn't lose it in a robbery, I mean, do you make the same leap there and say, oh, he's hiding this money, it must be money from ill-gotten gains or something like that? There could be a number of reasons.
Well, he was hiding his money, but he wasn't chewing his money. You see what I'm saying?
Yes, Your Honor.
To me, it suggests a classic destruction of evidence. And I don't know what other fact you could reasonably infer from this.
But he never closes the loop and says, I believe that based on what he did, I need to go search.
Well, we have to be reasonable and look at this. Hypothetically, if this came up here without a warrant, I'm not as able as the other judges in pulling cases out of the air, but I bet you we've sustained weaker situations on warrantless searches of automobiles. Automobiles are a special situation for searching for contraband and
yes, I understand.
evidence of crimes.
I understand.
And we've had a lot of them where they didn't go get a warrant. And we've criticized them. We might have sustained it, but said that it'd be good and helpful if somebody run this by a judge somewhere. But, which is what they did. I mean, the process here is commendable. They went to the judge.
I understand, Your Honor.
And anyway,
well,
you're doing a good job.
Thank you.
As
I'm
we
going to go ahead.
expected you to do. We appointed you, I think.
Right. I'm going to go ahead and cede the podium.
You save some time.
Thank you.
Thank you.
Before I begin, may I remove my mask?
Yes. Yeah. Oh, yes. Absolutely. I should have said something about that earlier. I'm sorry. Hartwell Davis.
Yes.
Good to have you here.
Nice to be here. Thank you, Your Honor. I'm just going to remove this. There we go. May it please the court, Natasha Harnwell Davis for the United States. This court should affirm for any of three reasons. As this court has principally been addressing the probable cause, I will certainly focus my time on that, which is to say that the magistrate judge had a substantial basis to find that the affidavit showed probable cause to search both the phone and the SD card. But there are two other grounds for affirmance, should the court reach them. The first, of course, is the good faith exception. And the second is that images of child sex abuse that were found on Mr. Orozco's phone or the SD cards independently support the conviction, which Mr. Orozco conceded at page 32 of his brief. Turning to the probable cause, which is where this court is focusing its attention, a reviewing court gives great deference to a magistrate judge's determination that the totality of the circumstances described in the four corners of the affidavit established probable cause to search the SD cards and the smartphone that Mr. Orozco had on his person.
Can you
displaying-
talk, can you just help me understand from your perspective, like the role that boilerplate plays? You know, we use this term boilerplate, and I think it's generally not used as a positive. I think your opposing counsel thinks it is a positive, at least, or would have been a positive here. You know, he goes through and he says, like, you know, the guy tried to eat the SD cards, right? But he then doesn't, like, as your colleague would say, close the loop by saying, and one trying to eat digital media must be trying to hide something, right? I mean, that second step, which seems, you know, would have been, I think, fairly easy to say, and might well be obvious. How should we think about the need for an officer to, like, as your colleague says, close the loop, I think was the language he used, to say, if you're trying to eat digital media, you might be trying to hide something. That last piece is missing-ish here. How do we think about that, and how do we think about where to draw that line?
Absolutely, Your Honor. I believe the common sense, so there are plenty of cases that say a magistrate judge can make a common sense inference, and I believe in this circumstance that trying to eat the SD cards provides a reasonable common sense inference that Mr. Orozco was attempting to conceal evidence from the officers. I think.
And how far does that go, right? So now take that away from the SD card into the phone, and hypothesize for a minute that we don't have this GPS issue, right? Assume they didn't see anything in the GPS. We often see language about, you know, an officer's training and experience that drug traffickers keep information about their drug trafficking on their phone. But, you know, the real answer is that that's just a more specific example of the basic idea that you see in Supreme Court cases on down, that we keep enormous details about our lives on our phones. And that's an idea that is not specific to drug traffickers at all, right? It's, if you want to know something about what you're engaged in, I suspect if I looked through your phone, I'd learn a lot about your work. And if your work was drug trafficking, I'd learn about drug trafficking. If your work was being an AUSA, I'd learn about being an AUSA, right? So what about that? I mean, is that a natural inference that that a magistrate judge can draw, or we can credit a magistrate judge drawing? That's maybe not quite as easy as if you're eating digital evidence, you must be hiding something. But is that the same kind of common sense inference that we permit magistrate judges to make?
In general, yes, and I would say particularly in the drug trafficking context, because in drug trafficking you are coordinating with other people. So you have, returning briefly to this case, you do have the phone displaying the GPS, but you also have the presumption based on Mr. Orozco's statements that someone else was paying him to drive this money that was hidden in the car, and the car belonged to someone else. So you could also reasonably infer that the phone would give the officers information about who he was coordinating with.
Why? Why would there be information on the phone about who was working with him in this operation?
Generally because people use cell phones to coordinate, so someone might text.
Well, but doesn't that cut both ways? I mean, if these are very sophisticated drug dealers, maybe they don't use phones because they know phones trap you time and again. You always get in trouble if you use your phone because you can never erase it completely. So let's say they're very sophisticated. And so why would there be any basis for thinking that these people might not have a system that doesn't involve cell phones?
Because I believe there's no evidence of that in this case, Your Honor. Admittedly, there are some drug trafficking.
Well, but I know, but I'm saying it seems to me, other than the GPS issue, because that is a factual circumstance that points to the cell phone's involvement in this man's conduct on the night in question, okay? But aside from that, I don't see where you have anything else. You say that his phone number was associated with an open DEA case, but we don't know whether he was a suspect, whether he was an informant, whether he was a neighbor, somebody entirely innocent. We don't know anything about that open DEA case, do we?
No, Your Honor, we don't, but it does go to the totality of the circumstances.
Well, what does that suggest? That he was a neighbor of this person, that In other words, it seems to me that what you're asking us to do in evaluating probable cause is to take the most suspicious take on the facts as opposed to a balanced take on the facts. And I agree with you that the cell phone GPS issue is a direct link, that his evasive behavior regarding his use of the GPS on the cell phone is a factual circumstance that cuts in the government's favor. But it seems to me that the rest of the ties to the cell phone could cut either way, and you're just arguing the most suspicious take on it. Could you comment on that?
Well, yes, Your Honor. I mean, certainly they could cut both ways, but the question is, did the magistrate judge have a substantial basis to believe that there would be a fair probability of finding evidence of drug trafficking on the phone? And the government, in an affidavit, does generally present the most suspicious evidence that it can provide because it is looking to obtain further evidence. So it's asking a magistrate judge to make kind of the most suspicious inference, even when it is legal conduct.
Can you walk me, I want to make sure I understand this, because I think Judge Keenan raises a good point, right? So just walk me through the links that you're trying to make. I take it you're saying at step one that we know from this guy's own words that he was paid to drive somebody else's car with drug money in it. I guess he doesn't say the last part, but we have that inference that's pretty clear. And then the second step in that process is that everyone today uses cell phones to communicate and coordinate. And the fact that he's got two of them suggests that he too uses cell phones to communicate and coordinate. And so you would then say, therefore, that is, at least for probable cause, like doesn't get you beyond reasonable doubt, but probable cause that the phone would contain evidence of that coordination or communication. But then I think Judge Keenan raises the good point is, well, but maybe they're like quite sophisticated, right? And so that they're not the type of drug dealers who are sloppy enough to do that. And what I'm not sure you're saying on that step, there are two possible, maybe more than two, but let me at least give you two. I want to see which one you are arguing. One is that it's just a fair probability. And so, yes, they might be a sophisticated drug dealer, but they might not be. And so just like positing a possible innocent explanation, or in this case, not an innocent explanation, but a reason why the phone wouldn't have it is not enough. So that's option one. Or is option two sort of more case specific, right? Which says, people who have someone who's driving a car without a license and who are so sloppy in putting, cash behind the dashboard that you can tell the dashboard's been moved, they're not sophisticated. Are you? Which of those is the point you're making?
I think it's the first, Your Honor, but of course the second supports our position as well.
Okay, and so why is the first? Help me understand why the first works without a statement from an agent providing us some background on it, right? Because it is true that we all naturally know that all of us use our cell phones to communicate and coordinate. But we also sort of intuitively think that, drug dealers are not necessarily always like us. And so how does the magistrate judge make that common sense inference as opposed to like a training and experience inference? I get it if there's a training and experience inference and you've got an expert that's doing it, but the common sense inference there, help me understand why that's a common sense inference and not like sort of expert kind of testimony issue.
Because, again, going back to the crime at issue here, drug trafficking, generally people, in order to traffic drugs, have to coordinate with others, and they generally do that through a cell phone. So,
okay, so that last part, what's the evidence of that other than the broad point that all people generally communicate through cell phones? How do you then connect that down to, and drug traffickers too?
I would say it's a common sense inference that
that they're not that different from us, is another way of saying.
Correct, Your Honor, yes. I do want to address Your Honor's point about Cobb, which I think is directly on point in this case. As You may recall Cobb is a case where a suspect directed his father to, quote, clean a laptop in order to remove data from it. And this court determined that that supported probable cause to seize and then search that laptop for evidence of a homicide investigation. I think, of course, the circumstances of the traffic stop here support the magistrate judge's determination of probable cause. You have the large quantity of cash that was found hidden in the car, the canine alert, Mr. Orozco's profound nervousness in the form of uncontrollable shaking, sweating, his closing out of the app when the officer asked him his destination, the DEA associated phone number, and of course his attempt to eat the SD cards is highly suspicious. It doesn't sound like it, but just in case this court thinks that it is a close question as to probable cause, the good faith exception would apply. That's because the officers did obtain a warrant and relied objectively and reasonably on that warrant. The goal of suppression would be generally to deter officer misconduct, and that is not something that Mr. Orozco has alleged here. Of course, the court can consider uncontroverted facts that were inadvertently omitted from an affidavit. So in this case, I believe Agent Clutter was aware that the SD cards were compatible with the phone, so that would be available to this court in the good faith context. And the final point that I'll make is that the cell phone and the SD cards all contain images of child sex abuse. I have created a chart to show that
I think we got that part.
Okay. So just briefly wrapping up that point, each of those devices would be grounds to affirm in this case. So unless the court has any further questions, I would urge this court to affirm. Okay, thank you, Your
very
Honors.
much. We appreciate it. Mr. Groundhamel?
Regarding the issue about the good faith exception, I would just say that reasoning that good faith exception exists here because the warrant, the magistrate went ahead and issued the warrant is circular reasoning. It's like saying the word of the Bible is true because the Bible itself says it's true. So I would ask the court not to rely on that. In terms of, Judge Richardson, you said something, why isn't his trying to chew up the SD cards evidence that he's trying to hide something? My argument is that it shouldn't say hide something, it should say hide evidence of a crime. That's where you have to take that extra step. Lots of people try to hide things, but they're not necessarily committing crimes. In terms of the harmless error, even if the court says we think there was enough in this application to search the cell phone, but not enough necessarily to search the SD cards, Orozco still deserves a new trial because the jury was asked to determine if the electronic media had images of prepubescent minors, i.e. minors less than 12. And there's no distinction in the record on what those images on the cell phone were, except to say that they were also contained on the micro SD cards. But the jury didn't go through and say, this card had prepubescent minors, this card didn't, the cell phone had them, or whatever. And if there's a partial suppression here, the jury was still asked to comment on it, and it should go back to the jury to comment on it if the court is of the opinion that there should have been partial suppression but not full suppression. And in terms of substantial basis versus fair probability, I guess the issue in this case is at what point do you draw the bright line? At what point do you say that's a reasonable inference, and then you get to a point where you say, now you're just speculating, or you're just drawing conclusions and asking the magistrate to rubber stamp them. And I think this is a good case involving that. Admittedly, it could go both ways, but in the overall, the big picture, the guy was arrested on a misdemeanor. He was transporting cash, paid to be driving cash.
Can you just comment for a minute on the discussion I was having with your colleague? I mean, I think it's Carpenter, but there are a number of cases, both the Supreme Court and otherwise, that talk about the ubiquitous role that cell phones now play in our lives. Right? This is not a fact that we need an expert to tell us. If I wanted to know about you and I had access to your phone, I would learn a lot about you. All good, I'm sure. like, why isn't that like just a natural inference that we draw about people in today's world? See Carpenter, right? Like, as Carpenter recognizes, like, they are our lives now. And so if I have probable cause to believe that you're engaged in drug trafficking, and I've got some reason to connect that phone to you, why isn't that enough on its own, given the sort of inference that Carpenter permits to be drawn? At least to say we would permit a magistrate judge to do that. Maybe the magistrate judge isn't required to make that inference, but if the magistrate judge makes that inference, standing alone, take the GPS data away, why is that not enough, given what Carpenter teaches us about, like, the role that cell phones play in our lives?
Because it erodes the right to privacy in general, where you say, if I suspect somebody of committing a crime, I got reason to search anything and everything they use in their daily lives.
But you agree, I think you agree, that if the agent had said, paragraph 17, right, in my training and experience, right, laid out some sort of information, drug traffickers that operate in this way or couriers that operate this way, contain contact information of the people that they're trafficking drugs for, right? If he had closed the loop, as you indicated, that would suffice. And what I'm saying is, Carpenter teaches us that, like, that's not a law enforcement issue. Like, that's just true in life. Right. And, if the magistrate judge said, this link isn't closed here in the affidavit, but I've read the Supreme Court's decision in Carpenter, and I think that same inference in Carpenter, like, I can understand it, and I can apply it in this context. Why is Carpenter not, like, basically the inference that we're talking about?
I think there comes a point where you got to say, okay, you can't go too far in these reasonable inferences. I cited the case.
Well, but you don't think Carpenter went too far, did you?
Well, no, I'm not saying that, Your Honor. But I cited a case in my brief, and it wasn't an appellate decision. I think it was a district court opinion.
You can go as far as it's reasonable.
Right,
Well,
but
that's the reason we say reasonable inference.
But it was, yes, but that case I cited in my brief was something to the effect of, a guy who's arrested for a misdemeanor, it doesn't seem reasonable that you should be able to search any and everything in his cell phone based on being arrested for a misdemeanor. And so at what point, if the court wants to draw a rule of law or a bright line that says, if you're suspected of being a drug trafficker, we're going to allow the police to search your cell phone.
Guy's a drug runner, based on the affidavit. He's a drug runner, he's a courier, he's a mule. That's what that was his part in the whole thing, at least, at the minimum.
Well, if the court wants to draw a rule that says, if you're arrested on these facts, a magistrate has a right to issue a warrant.
Well, all you gotta do is look at the affidavit, which the magistrate did.
And again, he didn't say, like for example, on the SD cards, he says, he put the SD cards in his mouth, started chewing, but he doesn't go on to say, and in my experience, when somebody's arrested, brought down to the police station, and they do something like that, they're not trying to just hide something, they're trying to hide evidence of a crime. That's what I mean when I say closing the loop in the affidavit. So, I ask you to reverse the district court's decision in this suppression case and award Mr. Orozco a new trial. Thank you.
Thank you very much, sir, and I know you're court appointed, and we appreciate your work, helping us and assisting the system.
Thank you, Your Honor.
Thank you very much. We'll take this case under advisement. If we were able to do so, we'd come down and shake hands, as the Fourth Circuit does, and greet you, but we don't do that now because of the pandemic. Maybe next time you're here, we'll 887, the United States versus Gis Davis. Mr. Trevette,
Yes, Your Honor.
good to have you with us, sir.
Thank you, Your Honor. Your Honor, may I remove this?
Oh, yes, absolutely. Absolutely.
Thank you.
Thank you for reminding me.
May I begin, Your Honor?
Go ahead.
May it please the court. My name is Bill Trivett. I'm appointed to represent Mr. Gis Davis, the appellant defendant in this case. I'm going to address 3 points, perhaps 3 issues. Did the district court err in finding that this case presented a Terry stop and that reasonable suspicion supported the stop and the frisk, the search? Secondly, and I won't spend a lot of time on this, did the facts of the case really show a seizure, not an investigative stop? But thirdly, what is the effect of the recent Fourth Circuit case of United States v. Buster on this case, which was decided long after the case was presented in the district court? First, this occurred on October 3rd, 2018. I'm guessing, because the record doesn't state exactly, that the events took place probably between 5 to 10 p.m. I'm not sure exactly. It was dark, but the location is a big, think state fair, except it's put on by the city of Winston-Salem, and done annually, then called Dixie Classics Fair, now Carolina.
Out there at the Coliseum, isn't it?
Right across the fairway, yes sir, contiguous to the Coliseum, exactly. Done every year, attracts families, children. This is done during the evening hours, but think more Times Square, not a dark street. Winston-Salem police have a gang unit, and the 3 officers that are involved in this stop search are all members of the gang unit. And as the name implies, a gang unit focuses on gangs. 3 officers are involved: Singletary, Montgomery, and Jamerson. Singletary, first, is in what I think is probably, looking at his computer, in the command center there at the fair. And he notices a post. The gang unit focusing on gangs monitors social media, including Facebook. This Facebook post comes up, attributed to Mr. Gis Davis. It's not disputed that he posted it in the district court. It was in Chando was the username, but it was attributed to him. Singletary knew that Mr. Gis Davis was a felon. He was a member of a gang, and he knew some other information. It's not really significant, all the things he knew about it, but he was concerned enough that he texted out to his gang unit there. And by the way, the gang unit appears from the record that was their duty during the time of the fair, to have the gang unit there. And in the words of Officer Montgomery at the hearing, we're there at the fair for the sole purpose of preventing violence from happening in public places. That's at Joint Appendix 29. So Singletary was concerned enough that he texted out the post. And I'll now move to what Officer Montgomery testified to at the hearing in the district court. He gets the text, he logs into his Facebook account on his cell phone, and he sees the text and he interprets it the same as Singletary did. I should back up a little bit. Here's the text, and you probably have looked at that. Oops, O-O-P-S, I'll talk about more how they interpreted oops, but to me, I would say oops, like I forgot to attach something to my email. Oops, see me at the fair? Yeah, I got it on me, little boy fanny pack gang. That was the text that caused Singletary, and he testified that he interpreted that Mr. Gis Davis would be at the fair and he would have a firearm or a weapon in a fanny pack. Officer Montgomery got the text and interpreted the text, the cryptic phrase, the same way as Singletary. He knew that Mr. Gis Davis was a felon, knew he was a member of the gang, He had actually participated in a probation search of Mr. Just Davis, I think probably a year before, accompanying the probation officers who did a warrantless search. So I guess he knew what he looked like and probably remembered him. At the fair, I should say that Montgomery noticed that the day before, since he was on the Facebook page, that Mr. Just Davis appeared in a picture with a fanny pack. Fanny pack being something you normally think of worn on the backside that can carry small items. He also was very much on alert because they said that there was a patron struck by a bullet. They didn't say that somebody shot the patron. They certainly didn't say that Mr. Just Davis was involved in this, but they were on higher alert because somebody had been struck by apparently a bullet. Don't know, that's kind of vague.
Generally speaking, though, we think if someone's struck by a bullet, that it happened because somebody shot a gun.
Yes, sir. I have to agree with that. Record's kind of vague on the facts of that. The record also talks about a shooting, and Mr. Montgomery, Officer Montgomery, knew about a shooting that involved Mr. Just Davis at his house. The record is very vague on that. The implication the officers, I'm sure, were drawing from it is that as a member of the gang, he's a victim. But the record's not real clear through their testimony. Nevertheless, there was a shooting that came into their calculus.
And how long before this had that shooting at his house occurred?
I think it was within a month, Your Honor, and there might have been more than one incident. So obviously, they testified that came into their calculus regarding reasonable suspicion. Now, I want to now move to the testimony of the third officer, Officer Jamerson. And at page 74 of the joint appendix, she testified, specifically, the gang unit is there at the fair to patrol the fairgrounds to ensure the safety of everyone, but also, more importantly, to be on the lookout for gang members and the signs of violence that often accompany gang members at the fair. I realize this cuts both ways, but my point is a gang unit is focused on gang members, and we'll talk more about that later.
Well, they're focused on gang members, but it actually tells us why they're focused on gang members. That's because gang members bring violence with them. And if you're like at a fair, preventing violence seems like a laudable goal.
I have to agree, Your Honor. And
I mean, they're not looking for gang members for the sake of gang members, right? They're looking for gang members, as she explains, because of the violence that typically comes with them.
yes, sir. I won't disagree with that. So at some point, by the way, Officer Jamerson interprets the text. She testifies the same way. She knows the same thing. I think that the officers collectively get to say this is what we all knew as a group, and that was what they were relying on for reasonable suspicion. Jamerson joins up at some point with Officer Montgomery, and they say within 15 minutes or so, they're going about the fair, looking for Mr. Just Davis. Officer Montgomery testifies he sees him at a distance. Now, I'm not exactly sure if by the way, a third patrol officer has joined them at some point in this situation. Not a gang member, but Jay Ray is his name. I'm not sure if all three officers were walking down the fairway and walked past Mr. Just Davis, but Officer Montgomery testifies that he makes eye contact with Just Davis, and there's a reaction. Just a reaction, but if it was three officers side by side or even just Officer Montgomery walking independently, he said he got a reaction from him.
They said that I may not remember the record so well, but I thought he said they spread out across the fair to try to find him.
But I don't think the record is clear with
It does say at some point that they spread out, right?
I don't disagree, Your Honor. Probably did. But at the critical time, there are three police officers present. Jamerson, Montgomery are both gang members, gang squad, and they're dressed in police uniforms, and the patrol officer, we would assume, is dressed in police uniform. So they were known. So if Mr. Just Davis sees one or more of these officers, clearly, maybe he reacts. Jamerson and and Montgomery are together.
Wait, why, you said surely he react, why is it that you think he reacts? Because he's got a gun and he's a felon?
Well, Your Honor, the evidence is clear that he had a gun in the fanny pack, and if that's the end of the count.
And that he's a felon too, right? Not that just he's prohibited from having a gun at the fair, right? That is a separate problem, but he's a felon, so he's totally prohibited from having a gun.
He is, that's correct, Your Honor, on all
Well,
points.
tell us, Mr. Trowett, what should the officers have done?
I
I mean,
think
they have this information, they think, according to gang speak and their experience, that this man is bringing a gun to the fair. He's a convicted felon. He has a record of armed robbery, doesn't he?
Yes, sir. Yes,
and-
ma'am.
Yeah, and so what are they supposed to do? You're saying they had to wait till he pulled the gun?
I contend that, like in Terry v. Ohio, they should investigate. This case was decided on a Terry stop. Why? It's
Why
easy for.
wasn't this a Terry stop? We've said in Elston and in some other cases back in the 90s that the mere fact of applying handcuffs does not per se convert a Terry stop to an arrest.
Correct.
And you had a crowded fair, at least there was some testimony that at points people were shoulder to shoulder. What were the police supposed to do here? That's what I'm trying to understand. What was their alternative?
I'm going to argue that they should have investigated more. They should, there's 3 police and 1 suspect.
You say they should gotten a warrant?
No, Your Honor. No time for that.
They should have gotten a warrant.
They should have investigated. I'm taking the
They
position.
could do this without a warrant. You agree to that?
Yes, Your Honor. Absolutely.
Why wasn't this a Terry stop?
Because
Because
they-
they were patting down, weren't they patting down the fanny pack, they were patting down his person. The fanny pack was on his person. So I guess what I'm trying to do is take your perspective to the next step, and if they had not patted the fanny pack and had restricted themselves to his body only, were they then, required to let him go and take off the handcuffs and access the fanny pack when their evidence tied the gun to the fanny pack, not to his body?
I understand your point, Your Honor. I'm taking the position that, as in Buster, well, the record's not completely clear. It's not clear at all as to when the fanny pack was removed from him. But here's the critical point.
But it was on him when he was patted down.
I won't concede that, Your Honor. I don't think the
I
record
think
says it.
that was in the video, wasn't it?
Well, yes, Your Honor. The video, and obviously you've seen it, it shows the fanny pack in front, not in back.
Right.
But his hands are behind him. I'll say that the critical point about Buster is that not that in Buster they removed the pack or whatever they had and put it aside, and the court held he was disabled, he was on the ground, he could not get to it. My critical point is this: if Buster is the law in this circuit, which I think it is today, just Davis was disabled. Montgomery testified he took over because Jamerson first grabbed him. Very quickly, Montgomery must have grabbed him because the testimony was that Jamerson handcuffed him. At that point, he's disabled. The bag is in front of
Why
him.
isn't it a valid distinction, though? Because Buster, the court is talking, Judge Heitens is saying that this was not simply a quick frisking of a suspect or a bag. It was a search of a bag. And here we didn't have a search. We had a pat down of the bag. The officers felt the hard object. And at that point, applying that information with their information that he was coming to the fair with a gun in his fanny pack. So it's not a Buster search where the bag had been cut off the person and removed to another location and searched. He was simply patted down, and the pat down included the fanny pack because the factual suspicion pointed to the fanny pack. So it seems to me we've got a little bit different case than Buster, and you've got to tell us why we extend Buster to this situation.
And that's a fair question, Your Honor. And I say that like Terry v. Ohio, in Terry v. Ohio, this officer, McFadden, I think his name was, he approaches 3 people, and he goes up, and the court found he ultimately had reasonable suspicion, and he investigated, he talked to them, spun Kerry around, frisked him, felt the gun, and took it off of him. I say that the Buster decision applies to the case where the suspect could still get to the weapon. And the critical part about Buster is that Buster was immobilized on the ground. In this case, Mr. Just Davis had the handcuffs on him when the frisk was done. It's not I take the position it is not a material distinction in the facts. This court obviously makes the vote. I do not, but I'm taking that position that he was disabled. He couldn't get to the...
And I think that's a really good point, but you still haven't explained why the fact that Buster, the holding was predicated on the fact the bag was completely searched, okay, without probable cause. Here, you had the pat down where the officer felt the gun, plus you had the situation where the officer had the information ahead of time that he was coming to the fair with a gun in his fanny pack. So this wasn't a complete search, as in Buster, that the court invalidated. It was a pat down here of the fanny pack that was on his person as part of the Terry frisk. So if you could account for that distinction, it wasn't a full search, as in Buster. Could you address that?
And I have to go back to and I see your point that there was the officers in Buster may not have known that there was a weapon. I don't think, I'm going to argue that that is not the critical distinction, and I go back to the fact that he was disabled, he couldn't get to it. And the court asked, was he required to get a warrant? I'm going to argue that under these facts, like in Buster, there should not have been a search, even when the officer felt it.
Okay, but here in Buster, the opinion says the government offers no explanation for how the contents of the bag presented any credible threat to the officer's safety at the time they searched it. Okay, now, you're saying then that simply because he was handcuffed, there was no credible threat. Well, what happens afterward then? Let's just say the officers agreed with you and said, well, he's handcuffed. He really can't get to this fanny pack because I think the video showed it was on the front of his body. What if they agreed with you? Then they just let him go?
No, Your Honor, they at that point have to get a warrant to search the fanny pack.
I thought you said they didn't need to get one.
Not in advance of the search. I apologize, Your Honor. I misunderstood the question. Obviously after Officer Jamerson did a frisk and felt it, because the record doesn't say the fanny pack had been removed. Obviously, if it had, I think the court might agree that this case was very much on point with Buster. But I do...
It was a .38, wasn't it?
The weapon, Your Honor?
Yeah, 38
I'm not sure.
caliber.
I don't know.
It was loaded.
I think that's the record, yes, sir. Well, I see I'm red.
You've used all your time and you've saved some. Let's find out what the government has to say about this.
Thank you, Your Honor.
Mr. Gallion?
Thank you, Your Honor. I'll remove my mask. Is that okay?
Yes, sir.
Okay. May it please the court, Mr. Trivett, Randall Gallion for the United States. I'm from the Middle District of North Carolina. Your Honors, this case, the district court correctly denied this defendant's motion to suppress the admission of that firearm because based on the totality of the circumstances, the Winston-Salem Police Department's gang unit had reasonable suspicion necessary to stop the defendant in this case. In reviewing the evidence in the light most favorable to the government as the prevailing party in this case, this court should affirm. In considering the evidence adduced by the 3 gang unit officers during the course of the suppression hearing, the evidence was that Mr. Gist Davis they knew he was a felon, they knew he had been convicted of robbery, They knew that he was a validated gang member both while he was in prison and afterward. That one of the officers, the gang officers who was actually involved in the validation was an officer involved in this case. That was Detective Montgomery, Travis Montgomery. And that he had validated him as a UBN member, that the United Blood Nation is a gang involved in violence and known to carry firearms. That testimony was all adduced at the suppression hearing as well. Layered on that, of course, Your Honors, is the fact that there was this ongoing gang feud involving this defendant in the time frame leading up to the Dixie Classic Fair on October 3rd of 2018. And that in the weeks preceding this October 3rd incident, that Mr. Gist Davis's residence had been the subject of drive-by shootings. And that same street that he lived on, Richard Allen, which is East Winston, that street had also been involved in essentially an ongoing gang feud as well. And that the day before this incident, on October the 2nd of 2018, that Mr. Gist Davis, because he was a member of a security risk group, that is a validated gang member, they were monitoring his Facebook. It was a public-facing Facebook page. And that on that public-facing Facebook page, he had a picture of himself with a fanny pack. It's a Champion fanny pack. We know, based on the evidence, that that was the same fanny pack he had the next day, October 3rd. So he has the fanny pack on October the 2nd. He posts to his Facebook page. Then the next day is when he posts at 10:02 in the evening to ops, see me at the fair, I got it on me, little boy, fanny pack gang. There's the red devil emoji at the end of that. And then after that post, shortly after that post, someone responds, let him know, Chan. He's putting people on notice that he will be at the fair. He's been the victim of violence before. His house has been shot up. And that he's going to go to the fair. And as Judge Tilley pointed out, as the district court pointed out below, that I'm going to be at the fair, I'm going to be armed, and if you want some of me, I've got it in my fanny pack. I'll be armed and ready. You will not get the drop on me. That was the essence of that post. And so there's the post that he made.
I don't want to criticize that, but why would that make any sense, right? That's the opposite of you won't get the drop on me, right? Like that's like, seems like to me it's like setting yourself up, right? Typically speaking, like if I was engaged in a feud or doing something like this, I don't announce it, right? If I go out hunting, I don't sit in the deer stand and announce that I've got a gun, right? Like I try to be quiet. Help me understand why. I'm trying to understand why he would announce it this way. What's the real point? It's not that I don't want to get somebody to get a drop on me, right? It's the opposite.
Well, I would argue, Your Honor, that it's putting people on notice. It's a warning. It's a warning to those who would do him harm that he's going to be armed. And so,
He wanted to start a shootout or something?
well, again, I think
He wanted to start a war?
I don't think it was that he wanted to start a war. I think it was essentially a prophylactic measure. It's, I've got a firearm. And so understand that, if you try to engage in violence at the fair against me, I'm prepared. I mean, that's the argument. And I understand the court's point as far as why would you announce it? But again, understanding, unfortunately, that in this Facebook world of I need to post and let people know what's going on, but especially I have to look, like I'm really a big shot, essentially.
The court observed that he kind of confessed or something spontaneously.
That's absolutely true, Your Honor.
Is that right?
That's correct. That during the
What was it he said?
he said that
What the defendant said?
the defendant said,
The court observed what the defendant said.
correct, and the defendant said after they conducted the search, y'all be monitoring the social media, basically that you all are really paying attention to this. And then he said, I told on myself.
Hold on a minute. But all that's after
That's true.
this.
That's true.
So it can't be taken into account for justifying the Terry stop.
It cannot. We can't bootstrap. But I do think that it's important, and I would argue that it's important in the sense that it corroborates, as the district court said, When Judge Tilley made his findings, that was one of the things he pointed out afterwards. And he said it's gratuitous, but here's the thing. It goes to show the reasonableness of the interpretation of the officers. That
The interpretation of the officer about what?
about the posts.
About the meaning of the post.
Correct.
Okay, but Mr. Gallion, it seems to me your argument is going on a parallel track to Mr. Trivett. Mr. Trivett's not really taking issue with these being the facts of the case. What he's saying is they had to get a warrant to search the bag, and then he raises Buster. So it seems to me in order to engage in this case, you're going to have to address Buster and Mr. Trivett's argument regarding probable cause and whether that was required. In other words, a warrant was required as opposed to a Terry stop. And in answering that and addressing that, I'd be really interested in you talking about whether the fanny pack was part of his body for the purpose of the frisk, or was it not? And give me the reasoning that you would go to get there.
Sure. Certainly, Your Honor. First of all, as to the last part first, the fanny pack is part of his body in the sense that a holster would be a part of someone's body if they had it on.
But he was handcuffed, so it still was part of his body?
Yes, absolutely. And here's the thing, this court has talked about the fact that handcuffs are not a fail-safe. So the situation that the court is aware of and the evidence at the suppression hearing is that they approach him from behind, that they get his hands and put him in handcuffs behind his back, that one of the other officers, Officer Montgomery, is there and has a hand on his arm, that the fanny pack is, the actual pack part of it is in the front. The reality is that that's far from being subdued. Understandably, he can't use his hands to the extent that he wants to, but he's still upright. And that's a tremendous distinction from what happened in Buster, where the individual is on the ground in handcuffs, face down. That's this whole idea of he's immobilized or he's disabled. That's not true. The fact that a person has handcuffs on is certainly some detention and some constriction, but it does not prevent the individual from running away. It doesn't prevent the individual from dropping to the ground and trying to get the handcuffs under their body. And so the other important distinction, too, is actually unlike a holster that would be, between belt loops on a belt, that the fanny pack, of course, is separate in the sense that it is on a loop, on a strap, and can be turned around. So even while he has his hands behind his back, he could access it if he turned the fanny pack around. And so to say...
That's speculation. We don't know. We don't know how tight the fanny pack was, do we?
Well, we don't know how tight it was, but we do...
You're just saying that it wasn't a fail-safe situation.
Correct. Absolutely. It was not. The other part, Judge Keenan, is the fact that the Buster court specifically exempted this very type of situation. When they talked about that this opinion in Buster does not address situations where a firearm was found on a suspect's person, and if the court is going to draw a fine distinction between the fact that it's in a fanny pack on a person versus simply in their pocket, that, I would argue, is too fine a distinction to make. So,
well, let's just say we end up agreeing with you and we're writing the opinion. Tell me how you would write the opinion. Is there any other way to write this opinion other than to say the fanny pack was part of his body for purposes of the frisk? Is there any other way to approach it?
Well,
and to affirm the case with regard to, can you say the fanny pack was not a part of his body and still affirm?
I would argue that the court could.
And how would you do that?
There are additional ways in terms of what Buster does not reach, and that is it doesn't reach a bag that was open before a suspect was subdued. Here, this defendant was not, I would argue, subdued, nor was the bag opened before he was subdued. There was a frisk, and that's different because, as the court knows, the bag in Buster was actually cut off of the defendant in that case, and so it's away from him. And then the third part is that would draw a distinction between this case and Buster is that Buster does not reach, as the court said, situations where the person is still within reach of the bag. And again, because the bag had been cut off and it was away from them, here, the bag is still on him. It has not been taken off, cut away, whatever. And
Didn't the evidence here also show this sort of idea of the plain feel? And you've sort of argued that when they went to pat him down, they've got some information on the front end, right? And they literally are patting the bag down. And upon patting the bag down, they then feel the gun.
yes,
And at that point, don't they have probable cause to, like, actually search him?
I would
Right? I
argue-
mean, that's part of the point in Buster that the court noted at footnote 2 is that argument was not made in Buster, and was not therefore passed upon, right? But it seems to me that's a distinction, that in doing the pat down, once you feel what the officer indicated believed was a gun, particularly in light of the prior information, that at that point we have enough.
I would agree, Your Honor. I would certainly agree that there's probable cause at that point that a crime is being committed because they knew he was a convicted felon. And so they knew.
Why wouldn't the officers, and I'm just throwing this one out for your reaction, why weren't the officers required to remove the bag from his body? They had all this information that he was a convicted felon, he was coming to the fair with a gun in his fanny pack. Why, when they stopped him and detained him, why wouldn't we require them to simply remove the fanny pack from his person at that point? Why?
In the same way that when Officer McFadden and Terry conducted a pat-down of the outer clothing of Terry, that he wasn't required to take his coat off in order to get the gun out of his left
Right,
breast
but they
pocket.
already had him in handcuffs at this point. The suspect wasn't in handcuffs in Terry, I don't think.
No, he was not.
Right, and
That's
so here the defendant's already in handcuffs, and the officer had all that information pointing to the gun being in the fanny pack. So why shouldn't we be instructing that the proper conduct in this case is to remove the fanny pack?
To remove it before the frisk is conducted?
Because the officers had the man handcuffed. Why not just unclip the fanny pack and remove it? And then there would be no issue of him getting to the fanny pack.
That's true, that there would be no issue of his ability to get to the fanny pack at that point. But again, the idea behind the investigation and the investigative search, the ability of officers to conduct a Terry frisk, it would certainly make sense that because it's actually on him that they would conduct the pat down as part of that frisk.
Would they need, so you need reasonable suspicion to do a pat down, but to seize the item, you might argue, in order to remove it and take it somewhere, you need probable cause, right? Because that's no longer a Terry frisk, which is reasonable suspicion, but if I take the bag off of you, I haven't really seen this argument made, but if I take it off of you and move it to the car, I've then seized that item, right? And we generally think that requires probable cause in order to do that,
Yes.
right? Where to pat him down, they only need reasonable suspicion. So an officer might well believe that in order to remove the bag and do something with it, I need probable cause to ensure that there's not a weapon, but nothing more. I get to do just a straight pat down, not a search of the bag, not a removal, not anything other than just the pat down. That's the sort of point of Terry, right?
Correct.
Has the government ever argued that this wasn't a Terry case, it was it turned into probable cause and it was a unwarranted seizure?
The government has not.
But there was probable cause. They didn't, under the circumstances, need to go get a warrant. Have you all argued that?
We didn't argue that in this, the government did not argue that in this case. We argued related to the reasonable suspicion, consistent with what.
You're saying it's all a Terry deal, but Judge Richardson makes a good point about you found the gun, you seized it.
That's correct.
And the Terry's pat downs.
That's correct.
for safety.
Yes.
Right.
And,
The rationale for Terry is the officer's safety, not for investigation. Isn't that correct?
well, there-
Wasn't that the rationale in Terry?
because it's a two-part analysis, I mean, the fact that there has to be reasonable suspicion that a crime's being committed and then that this person is armed and dangerous. And the interesting part about that, of
Right,
course.
right, but you answer the question, if you would, please.
Yes.
Is the rationale for Terry the pat-down for the officer's safety?
The safety of the officer and others.
Correct, but not for investigatory purposes.
That's correct. That's correct.
You said a minute ago an investigative pat-down, I think is what the point. I think,
And
and that's a misnomer, right? What you don't mean that they're doing it for they're doing it for safety,
Yes.
whoever safety that might be.
correct.
But investigation could be a word that goes with that. I don't know the fact that you throw in investigative control.
Right,
They're entitled to do what they need to do to protect themselves and the public,
that's correct.
if they have reasonable suspicion.
Yes,
But if they find contraband, drugs, guns, whatever they find, they can go from there. Now, whether they need to go get a warrant or not, Mr. Trevitt took two positions on that. He said they didn't need to, and then he says he's taking a position they did need to go get a warrant. Was that litigated before Judge Tilley?
no. The issue of whether or not he was arrested was not litigated before the district court. So that would essentially be plain error. There would be a plain error analysis. But government's argument, of course, is,
There was a pat-down and a seizure.
yes,
It was a search and a seizure. Or was that this pat-down never did turn into a search?
well, a pat-down,
You seized the firearm.
that's correct. I mean, as Terry points out, I mean, the pat-down does constitute a search. And so there was a search in the sense of a pat-down that was conducted, and this defendant had a firearm, and then the firearm was seized from the fanny pack. And again, that's because it's not just that they felt a hard object, that they felt a hard object consistent with a firearm. That was Detective Jamerson's testimony.
And if
at
they
the
knew
time.
he was a felon and they knew he had a firearm or found out he had a firearm, they had probable cause right there.
That's correct.
They didn't need to go to any magistrate and get a warrant.
No. No, Your Honor. That's correct. Your Honors, based on the fact that the testimony in the district court established that these experienced gang unit investigators believed that the defendant had a firearm on him at the Dixie Classic Fair back on October the 3rd of 2018, that the district court appropriately considered that information, and based on the totality of the circumstances, that the court determined there was in fact reasonable suspicion in the case, and that their subsequent pat-down of the defendant, seizure of the firearm was appropriate. Based on all of that information, we would ask that you affirm the district court. I'll be happy to answer any other questions the court may have. Thank you, Your Honors.
Thank you very much, sir. We appreciate it. Mr. Trevitt?
Thank you, Your Honor. And I will take issue with one factual thing that Mr. Gallion said, that I don't think the record supports that there was a gang feud going on. I'm pretty sure about that. As the court recognized, any
There've been
state,
multiple drive-by shootings at this guy's house, right?
that was in the record, Your Honor.
And his text message, at least interpreted by people who read these, or the Facebook messages interpreted by people that read this, referred to the opposition.
That's how the officers interpret it, Your Honor. We don't concede that that was reasonable, but that's the government's position. That's what the officers testified.
Turns out like that's what your client said after the fact,
I
right?
hate it when that happens, Your Honor. And as the court points out, things that happened after the search, statements made, can't be considered in regard to what
They can't be considered, but they can be considered to determine whether what the officers believed was reasonable, right? I mean, it'd be hard for us to say this was so unreasonable, no officer could believe it. And it turns out that it was exactly what your client said he meant by those words.
It's a good point, Your Honor. You understand I don't concede it.
I understand.
This case is really like Buster. I understand that there is this sentence.
Buster, your best case, I guess you found it after the fact.
Yes, sir. It was not argued. What we're talking about mostly today was not argued in the district court. The district court treated it strictly as a Terry stop, and he said there was reasonable suspicion. He didn't really address.
So when your client pled guilty and reserved the right to appeal.
Yes.
Agreement of the government. At that time, you weren't coming up here on a Buster issue.
No, Buster decided about 5 weeks ago.
And where you were going to come up here and argue that statement on the Facebook page wasn't enough to give them reasonable suspicion.
That was what was argued in the district court, and we certainly take that position today. But Buster does apply to this case because we're now on appeal. Plain error, I suppose that's correct. But it really, on the facts and the one distinction that was the firearm on him, we take the position that's more a statement of, like in Officer McFadden, he feels the gun on Terry and he pulls it out.
You don't contest the seizure, do you? It was a proper seizure, wasn't it?
I am contesting the seizure, Your Honor. I'm saying
Well, they knew he was a felon.
Yeah. And that he was in a gang.
Once they patted him down and found the gun, they had to seize it.
I have to take the position that Buster applies and that at that point, they have to get a warrant. I understand that's.
So they should have stopped at what point?
When she felt the gun, or immediately, since they had evidence, as Judge Keenan brought up, that there would be a gun in there, it should have been removed from him and put aside, and a warrant should have been obtained. That's really what I have to argue on these facts, Your Honor. That Buster still applies, and the fact that it was in the fanny pack.
Well, a reasonable suspicion gives them a right to a pat down.
Yes, Your Honor. If reasonable suspicion.
They pat down, there's a gun.
Is the fanny pack part of his body for purposes of the frisk? I mean, isn't that really kind of the nub of this?
I don't think I have a good argument to say that once they had disabled him and put handcuffs on him that they couldn't do a frisk. It certainly, the fanny pack, it appears from, I don't think the record's clear on that. That's the problem.
Well, when you look at the video, though.
The video very briefly shows it's in front, which makes sense. If you're going to grab a gun, it's going to be in front.
I had asked your opposing counsel, and this is something that seems to me to be a very serious issue we have to confront that might have a lot of application in future cases, on whether a fanny pack with information that ties the fanny pack to evidence of a crime, the fanny pack is part of the body, is no different than in a chest pocket of a shirt. That a fanny pack was part of his body for purposes of the Terry stop. In other words, you could frisk the fanny pack just as much as you could frisk his chest, his legs, everything else. I mean, that's really what we've got to face here, it seems to me, and I'd like your take on that.
I think that when Officer Jamerson did her pat down.
Excuse me?
When Officer Jamerson did the pat down, and she felt it, if the court is to find that they had reasonable suspicion to stop him, at which point we're not conceding, but if they had the ability to stop him and seize him and put handcuffs on him and they're still within a Terry stop, a pat down is appropriate. It's on his body. I think you understand the point that I've been making.
Yeah, I mean, it's an issue of law, so it's not something you can concede. I'm not trying to get you into any trouble. You know, we've got to come up with the answer, and I'm just interested in your perspective on it.
I think the court really understands these issues very well, and did I answer your question? I'm not sure I did.
Yes, thank you.
Thank you, Your Honor. It's been an honor to be here.
We thank you. We know you're court appointed. We appreciate your work and your assistance.
It's a privilege to be here, Your
in
Honor.
the handling of this case. And if we could do so, consistent with our protocols, we'd come down now and greet you in the well of the court, but we're not going to be able to do that. So we'll, next time.
Thank you, Your Honor.
Your next case, and we'll do that. And our third case of the day is United States versus Garris. Ms. Hoffman.
Good morning, Your Honors. May it please the
Good
court.
to have you with us, Ms. Hoffman.
Thank you. May it please the court, Megan Hoffman on behalf of Mr. Garris. Your Honors, as this court is aware, Mr. Garris has raised several issues regarding the Fourth and Fifth Amendment and also challenges to his supervised release conditions. To begin, the Fourth Amendment, as this court knows, is governed by reasonableness, and here the police officers acted unreasonably in several ways. First, they used excessive force to tackle Mr. Garris to the ground, causing an injury to his face. The force was so extreme that the fellow officer had to tell the tackling officer to stay calm and describing him as, "You were kind of committed, weren't you?" This was all for misdemeanor or suspected misdemeanor offenses committed by Mr. Garris.
When I watched the video, I hypothesize that I don't see it the same way you do. But my question is that if there's any ambiguity about that, don't we have to take it in the light most favorable to the government, given where we are, that the denial of motion to suppress?
Your Honor, I think that the standard governing the facts here, whether the district court clearly erred in making certain findings. And I think that even if this court were to find that the officer wasn't the person that pushed Mr. Garris to the ground, he continued the force once he was on the ground, causing the injury to his face. And I think that there are at least, that we can point to one significant point, for example, that the police officer, or the tackling officer here, testified that he did not reach Mr. Garris.
But you're calling the tackling officer, assumes the question, right?
It does, Your Honor. And certainly, we're making the argument here that the district court was erroneous in making its finding to the contrary. But I think that in this...
But I need to watch the video and find that it clearly shows that.
And, Your Honor, I think at our opening brief, and I would urge the court to look at the color photos. I saw some of the black and white photos as I was prepping for the argument this week, and they don't show them as clearly. But I think that in the color photos in the briefing, the officer testified that he didn't reach Mr. Garris until he was already on the ground on his hands and knees. And I think that the stills that we have in the brief clearly show that to be wrong. He was essentially on top of Mr. Garris by the time he reached him. And then Mr. Garris fell to the ground. And certainly at that point, the officer was not truthful. It was clearly erroneous that he had not reached Mr. Garris until he was already on the ground.
You're saying the judge made a finding to the contrary of that?
I am, Your Honor. Yes, that's correct.
So the judge clearly erred in that respect?
Correct, Your Honor. That is correct. And he did make, I'm sorry.
Is that the only point that you say the judge clearly erred in its recitation of the facts?
On that particular argument, Your Honor, we're arguing that in fact he did tackle Mr. Garris, and that in fact that was the reason that Mr. Garris was thrown to the ground and an injury was caused to his face. And I think in this particular instance, the seizure was particularly unreasonable because the tackling officer did not give Mr. Garris a chance to comply. He never said police, he never said stop, he never said you're under arrest. And under those circumstances, a reasonable person, which is the standard as Mr. Garris was, a homeless black man in Charlotte, North Carolina, would have left as he saw the officer approach. And recently, the Supreme Court in Lang v. California found that a person suspected of misdemeanor or minor offenses might flee for innocuous reasons and in non-threatening ways. And here, the officer did not even give Mr. Garris the opportunity to comply with his demands. Under Edwards and under Rouleau, we believe that suppression is the appropriate remedy for this excessive use of force. As we noted in the briefing, in this court's decision in Edwards, I'm from Las Vegas, so I keep deferring to Clark County. The Charlotte-Mecklenburg Police Department has a history of excessive force against its black residents, and it's likely to occur again, particularly in the context of this as a misdemeanor, suspected misdemeanor offenses. They did, in fact, cause injury to Mr. Garris, and suppression would be an appropriate deterrent where excessive force is used in the absence of exigency. In this particular instance, we argue that like I said, under Rouleau and under this court's case in Edwards, that Mr. Garris was, in fact, seized unreasonably, and that the evidence found as a result of that seizure be suppressed.
The judge found there was probable cause, right?
He did find probable cause, Your Honor, and of course, we disagree with those.
We're not talking about reasonable suspicion here. We're talking about probable cause.
The government argued both.
Why wasn't there probable cause that he was attempting to break and enter the car?
Your Honor,
it was 1:30 in the morning. He was casing the area, peering into vehicles. He then pulled down his shirt and used the shirt to cover his hand to try to open the vehicle. He was on a bicycle, so there was no reason to infer that this could have been his car. Why isn't that probable cause to arrest for attempted entry into a car?
Your Honor, I think my response to that is that Mr. Garris, under those facts, I think that in this particular instance, the government had to prove both that Mr. Garris had attempted to break into the car and also that he had the intent to steal something within. And I
Well, what other reasonable inference is there that he was trying to get into that car?
Your Honor, I think that there, I could think of another reason. I mean, for example, I accidentally tried to get into a car last week that I thought was my parents' rental car, right? I think that sometimes.
Did you walk around looking in every other car to see if there were valuable things?
I did not, Your Honor.
1:30 in the morning?
It was definitely not 1:30 in the morning, Your Honor. I agree. And, I think in this
Did
context.
you put your shirt over your hand so you didn't leave fingerprints on it?
I did not, Your Honor. And I don't, again, I think that in this particular instance, we would argue that what they observed was Mr. Garris attempting to get into the car, and I think that.
Is that a felony under North Carolina law?
It is not, Your Honor. In North Carolina, breaking and entering is a felony, but a misdemeanor reduces it by one level, which places it to a category, I believe it was a category I felony, or a misdemeanor. And so under these circumstances, it was, because it would have been an attempted breaking and entering, it would be a misdemeanor. I think it's also of note that when police arrested Mr. Garris, that they noted in their police report.
Police officer's supposed to make a distinction in his mind between whether an attempt to break into the car at 1:30 in the morning was a misdemeanor or a felony in determining whether he has reason to apprehend somebody.
Your Honor, I think that in this case, the officer should have known that it was only an attempted breaking and entering, and I think they even testified to that fact at the evidentiary hearing. The law in North Carolina is pretty clear that when there's a felony, but it's an attempt, it reduces the level by one level, which in this case would have been a misdemeanor, and the officer should have known that under Heinen. I also think, Your Honors.
Those distinctions that you talk about are confusing to judges, and lawyers. Why wouldn't they, the officer, why wouldn't they get the benefit of a more reasonable interpretation or the more favorable interpretation to them in a circumstance where it's in the middle of the night in a situation like this?
Your Honor, I mean, I think in this case, we also have to look at the totality of the
Is this
circumstances.
the orange BMW?
The orange BMW was earlier in the evening, and that officer testified specifically that he did not.
That made an impression on me, that orange BMW. I don't know if I've ever seen it.
That is a memorable case, Your Honor. I think that that was earlier in the evening, and that particular officer, who also happened to be the tackling officer, testified that he did not intend to arrest Mr. Garris for looking into the BMW. Indeed, when officers saw him looking into the cars in the diner parking lot, they again did not arrest him, even, and if
But
they're
there was
saying
a
they
pattern,
believed.
wasn't it? There was
It-
going around to different cars?
I think it's unreasonable, Your Honor, that they didn't arrest him at that point if they believe they have reasonable, if they believe they had probable cause to do
10 or
so.
Sort of like 404B evidence.
Right, but for here, we have to show probable cause, right, for them to be able
crime
to
spree.
arrest him. I'm sorry?
Sort of like a crime spree.
Well, except they never saw him actually taking anything. There was no evidence that Mr. Garris had actually taken anything of value, and the police let him go from the diner. And so,
You said just a minute ago, it was unreasonable, and I assume you mean that in the technical sense under the Fourth Amendment, to not arrest him once they had information that he had committed the crime.
I think in this case, Your Honor, if they really thought he was a danger.
What principle is that, right? So we think about in drug trafficking cases all the time, we allow investigations to continue to understand the scope of the activity. Indeed, in like extremely offensive sex trafficking cases, those cases aren't immediately ended in an effort to understand the scope of the activity that's taking place. What Fourth Amendment principle or case do you have that suggests to us that as soon as you know that some crime has been committed, you must stop your investigation and arrest him?
Your Honor, I think that I'm just arguing it being reasonable under the totality of the circumstances, that if, this isn't like a drug case, this isn't like a sex crime case where it
It's
isn't
a
on
crime
account.
spree is what it is, right?
But they never, in a drug case, when they see perhaps a hand-to-hand transaction or they have an informant who testifies that the defendant had sold him drugs, you have that there. You know that he has committed a crime. In this instance, they never saw him take anything out of any cars. So if they truly
But you don't have to take anything to commit a crime, right?
Well, in this instance, I would argue that neither party has been able to point to a case in North Carolina where a attempted breaking and entering has been sustained on facts such as these. But in any event, I think that if they truly thought that he had committed a crime, they should have arrested him then, rather than allowing him to go forth and break into other cars, which is what they did. Or
Is there any case that, I don't want to understand whether, because that seemed to be a central argument that you were making, that it's unreasonable to not arrest somebody the moment that you have probable cause to believe that they've committed a crime. And that idea just seemed totally foreign to me.
Your Honor, I mean, I think my example would be like in Terry, where he observed them committing a crime, approached them, and immediately patted them down. If this was a Terry stop, perhaps at the diner, we would argue that, fine, they could have approached him to see what he was up to. But they didn't do that here. And so that is the content.
The Terry thing's for safety.
Correct. But, I mean, in Terry, I will say that the officer approached them because he thought he was casing a store in order to
They don't need probable
search.
cause for a Terry stop.
Right.
Here, the probable cause.
No, I agree. And if at the diner they believed that they had, I mean, if they had reasonable suspicion, I wouldn't have objected had they approached him to ask him questions. But that is not what they did here. And instead, they tackled him in the park. I'm going to move on.
Can I ask, just for you to talk a minute about, with my colleague's permission, the supervised release conditions that you, I know you raise a number of arguments, and this is we've had some developments in the law since this happened. But can you talk about, give us the examples of the ones that you think are most concerning to you?
Sure. I mean, Your Honor, I think that I filed a 28J earlier this week just for clarification because I, realized it could have been a little clearer, particularly in light of our local districts ever-changing standing order for the supervised release conditions. But I would note, for example, that I still believe that condition number 7, which is the restricting travel condition, the court here found that it was consistent with the guidelines, and yet it's clearly inconsistent with the guidelines. The court didn't explain how it was consistent with the guidelines. For the ones that have actually already been changed by our district court, that would be condition number 8, which was the requiring self-incrimination. They since have amended that condition to advise the defendant of his Fifth Amendment rights, which they did not do in Mr. Garris's case. In condition number 9, they have added in our...
I'm sorry, make sure I'm understanding. Back up just a half second on that. So 8 and 9, these are conditions that have been changed by the local rules, but were not changed with respect to your client.
It was after judgment.
Right.
Correct.
Wait, what was after?
The amendment to those.
Right, but they didn't amend his judgment. They didn't
Correct.
amend your client.
Correct.
And so your point is, whatever we think about anything, those need to go back to be reconsidered by the district court.
I think that's right. I think also condition 9, which is the residence condition, they added a time frame notification. In condition 12, which is the contact with felons, this court recently in United States versus Oliver remanded a very similar condition where there was no evidence that the defendant was engaging in his crime with another felon, and so it was not reasonably related to the case.
But in this case, the court did clarify that Garris had no known felon relatives, right?
He only clarified as to relatives, Your Honor, but I would note, for example, that Mr. Garris had been working as a barber for some time, and perhaps a client of his might be a felon, and that could place him in violation of that particular condition. And so for the same reason that this court reversed in Oliver, I think it should reverse here. And then finally, I think probably the primary one that we also objected to was condition 17, which was restricting drug use.
Say 17?
Yes, Your Honor. And in that particular instruction, the district court eliminated the language of if required to do so by the probation officer, finding that I assume, based on this court's precedent, that it was an improper delegation that probation got to decide.
In order to satisfy your vagueness challenge, what would the court have to say regarding use of alcohol and unlawful controlled substances?
Your Honor, I think that one is definitely trickier. I think that if the court could just provide, excessive alcohol to the point of perhaps 0.08, or whatever the state.
You're saying the court would be required to give a blood alcohol level?
I think that that's often what happens. I mean, that is how they determine that he has engaged in excessive use of alcohol, is they will administer a breathalyzer or a urine test. And so in this case, it would be, if he had an illegal limit.
How does that put him on any more notice, right? I mean, all right, I mean, that's part of the challenge that we face, is that you can drink and not necessarily know where you are on that scale. Like some people keep a breathalyzer in their car for that reason, right?
Right.
But we don't require that.
I think though, if
right?
it was, I mean, excessive use doesn't necessarily mean illegal, to the point where you wouldn't be able to drive. I think an average citizen such as myself knows that if I'm going to have a drink, that there is a lawful limit in which I can engage in that. And here, Mr. Garris doesn't have any information as to what is excessive.
It seems to me that these restrictions are necessarily general. In other words, you have to conduct yourself reasonably. And the court can't really give somebody a blood alcohol level reasonably, because then would they be required to purchase a breathalyzer or submit to a blood test every time that they ingest any alcohol? So it seems to me the vagueness argument really comes if the person is charged with a violation, and then you say, no, he was never really put on use as to what excessive was. He may have had 3 drinks, but to him that wasn't excessive, and if the court had wanted to pin it down, it could have. Seems to me that that's where the vagueness comes down, because a court can't really quantify how many drinks a given person should have. The court doesn't know how they react to alcohol.
Your Honor, if I may, my time's over, if I can just
Go right
answer.
ahead. As long as you get questions, you
If I can answer, yes, thank you.
answer any more you get.
Thank you. Your Honor, I agree with that. I think that shoehorns, however, into the argument that it's an improper delegation to probation, because unlike the case in Comer, where there was information provided to the defendant at the sentencing hearing, at the revocation hearing, as to what would be prohibited, in this particular instance, probation is the person that gets to decide that. It's not something left up to the judge. And so we argue that Mr. Garris does not have notice of how he could violate that condition. Thank you, Your Honors.
Thank you. Mr. Doshi?
Good morning, Your Honors, and may it please the Court, Samir Doshi for the United States. The District Court did not err in denying Mr. Garris's motion to suppress, and its judgment of conviction, as well as the sentence that it imposed, should be affirmed. I'm happy to start wherever the Court would.
Can we start with the supervised release? And I want you to come back and say whatever you want on the other issues too, but can you start there? Because there seem to be a couple here that I were particularly interested in you talking about. But can you talk about, particularly, 8, 9, 12, 17?
Sure, Your Honor. So let me start with the first one you mentioned, which is number 8. We understand Mr. Garris's objection to number 8 is that it violates his right against self-incrimination. But the Supreme Court has held in the Murphy case, for instance, that truthfully answering questions offered by the probation officer does not violate an individual's Fifth Amendment rights. And because an individual can maintain to the probation officer a Fifth Amendment objection and can retain the privilege against self-incrimination. Of course, Your Honor, as with all of these conditions, including condition number 8, it is the District Court, Judge Conrad, that retains ultimate authority in determining whether a condition was violated and whether a punishment should be imposed.
It seems to me, Mr. Doshi, that we have just kind of a mess here, if you don't mind my saying so, because the trial court didn't have the benefit of our McMillan decision when it imposed these conditions, or any of the cases since. And we know now, based on Van Donk, for example, the court can't give to the probation officer the authority to decide whether a defendant will participate in drug treatment. We know that with regard to the question of submitting to a search without a warrant based on reasonable suspicion, we know that the sentencing guidelines talk about that in context of sex offenders. But the judge didn't address why, even though this man's not a sex offender, it should nevertheless apply to him. So we've got some of these special conditions, we've got some of these general conditions. The court changed some of them, but the record here is pretty clear as to what occurred in the district court. And it just seems to me maybe it makes sense to have the district court just start over again with the benefit of all the case law, our Boyd case and the other cases, because they seem to point in a very clear direction that the court has to be specific.
Yes, Your Honor.
Wouldn't that be the easiest way to handle this?
With respect, Your Honor, Judge Keenan, I would disagree. And I think the district court ably discharged its responsibilities
The
here.
United States agrees?
I would disagree, Your Honor. I don't think a remand would be appropriate on the conditions of release.
I was going to ask,
Okay.
why don't you just agree with Judge Keenan and that part of the case?
Yeah, why don't we have to reverse this, I mean, just on its face, why don't we have to reverse, shall submit to search without a warrant based on reasonable suspicion and/or consent? Doesn't the court have to give some justification for that? I mean, this is in the sentencing guidelines for sex offenders. It's not for people in his situation on a gun charge. So we don't have any explanation, and there were non-frivolous arguments that it was an arbitrary intrusion by government, by law enforcement, and the guidelines recommend this for sex offenders. And the court just said, fine. So why don't we have to reverse that? Let's just start with the most obvious one, to my point of view.
Of course, Your Honor. I have two responses to that. So first, and I apologize if I'm mixing up my dates, my understanding is that the McMiller decision, which vacated a judgment of supervised condition by Judge Conrad, was 2020, whereas the sentencing here was January 2021. And so on that narrow point, Your Honor, Judge Conrad did have before him this court's decision in McMiller, although I'm not sure he had before him Boyd. Leaving that aside and talking about specifically the reasonable suspicion condition, Judge Conrad mentioned the PSR and the defendant's criminal history, which include multiple instances and convictions of lying to officers and providing fictitious information, including declining to provide truthful addresses. That justifies an imposition of a condition where, to ensure that the defendant is providing truthful information to law enforcement, only after the probation office has a reasonable suspicion, they can search some of the defendant's belongings. So that is, Judge Keenan, where we see the nexus between the facts of this case and the imposition of the condition.
Okay. And what about the participation in the substance abuse program, another special condition imposed by the court?
Yes, Your Honor. So the way we read the last two sentences of Condition 17, which goes to the treatment program, is that Mr. Garris is obligated to attend a treatment program, but if the probation office determines that treatment is not warranted, it can absolve Mr. Garris of compliance with that requirement. And that does not run afoul of this court's non-delegation jurisprudence because of Comer and because of Van Donk. I'm happy to expand on that, Judge Keenan, but I know there are other conditions as well. So to expand on that point.
So it's the negative. So as long as the court says, you must do this, unless there's an exception, that doesn't violate the non-delegation. If instead says, you don't need to do it unless the probation officer requires you, that's giving the power to the probation officer. And that's Comer. That's
exactly right, Your Honor. In Comer, the condition was you shall not have a social media account except as probation lets you. And that was found not to violate the non-delegation doctrine of Article 3. And we think the same exact logic would apply to the last two sentences of condition number 17. Judge Richardson, I believe you asked about condition number 16 as well. I may be mistaken, the excessive use of alcohol. Or phrased differently, Judge Richardson, if there are any other conditions that I could help the court address, I'm, of course, happy to help the court address them.
why not? What about 12? I think 12, the felon one. I wasn't as concerned about the alcohol, but the contact with the felon. How do we have enough here in light of Oliver?
We think it's by virtue of the district court's reference to Mr. Garris's extensive criminal history. At least one, the cocaine conviction in '92, which was intent to sell to others, and of course the purchase of cocaine.
In '92.
It's a long time ago, Your Honor, but that didn't deter Mr. Garris from future criminal conduct. He has an armed robbery conviction in '97. He has
any reason to think that any of, other than the intent to distribute, are there any other of his criminal convictions that suggest that he was involved with that they were joint endeavors?
There are not, Your Honor, but notwithstanding that fact, we think the condition is still substantively reasonable for at least two independent reasons. So the first reason is that the U.S. Court's own website explains the felon condition, and one of the reasons it gives is that social science evidence indicates not interacting with other felons helps the defendant reacclimate back into society. And that is true in this case as well, given Mr. Garris's long and extensive criminal history, including the facts of this particular case. So that's, I think, point one, Your Honor. And point two, the district court did in fact consider how the felon condition was going to impact Mr. Garris. Judge Keenan, as you pointed out, talking to my friend on the other side, it asked Mr. Garris's counsel, are there any felons in Mr. Garris's family that he's aware of? And lastly, Your Honor, the felon condition only applies if Mr. Garris knowingly interacts with the felon and, in addition to that, does so without getting approval from his probation officer. So if he's got a regular customer at the barbershop who he knows is a felon, and that's going to impact his livelihood, well, Mr. Garris can just ask the probation officer, this is part of what I have to do with my job. I'm cutting this individual's hair, and there should be no problem with that. So unless there are any further questions from the court, Your Honor, the government rests on the arguments contained in its briefing and would once again request respectfully that the district court's judgment be affirmed.
Any other questions?
Do you have anything?
Thank you very much, Your Honor.
Very good. We,
She's got a few minutes.
pardon,
She reserved.
you got rebuttal.
Yeah, just a couple
Yeah,
minutes.
rebuttal.
It should be brief, Your Honor.
Yeah.
Your Honor, I just wanted to, and I apologize for not offering it earlier, but one of my colleagues advised me that in another case in front of this court, the government recently agreed to remand based on the changes in the district court standing order on similar points that we have here, and that was in United States versus Samuel Harris. It's docket 21-4063. And in my understanding is that the government did agree to remand in that, or they did a joint remand before even argument.
So that happens sometimes, but it strikes me that that sort of depends upon the specifics of the case. Like, what did the district court say or not say? And so, I'm curious if you'll take just a minute, take, for example, the substance abuse program. It seems like to me this positive, negative difference on a delegation idea, when we think about it in sort of congressional non-delegation cases, that makes a difference.
Sure.
It seems like it makes a difference here. Can you help me understand why you disagree with the government on that?
Your Honor, I think I disagree with the government because the district court's amendment clearly adopted our position.
All right,
So-
but that doesn't change it, right? That doesn't make it, like, the district court standing order doesn't overrule Comer, right, for example.
Sure, and this isn't what we're talking, I mean, in this, if I can just read you the first line of the actual condition, the defendant shall participate in a program of testing for substance abuse if directed to do so by a probation officer. And the remaining two paragraphs talk about how the probation officer will supervise the participation in that program, but that is still requiring, it is the probation officer's decision whether or not he participates in drug treatment, not the court's. And so the district court, in recognizing this court's guidance in Boyd, Ross, McMillan, and even in Comer, eliminated that portion, and now it just reads that the defendant shall participate in a program of testing for substance abuse, period. Then it explains how the probation officer will monitor and supervise the defendant in that program. That is consistent with Van Donk. And so in this particular instance, I think that the condition itself is just on its face an improper delegation to probation. I think condition 18, we would agree, Your Honor, that the government or the district court never addressed our argument that it is only for sex offenders. And so merely reciting that this is consistent with the guidelines isn't enough under this court's authority, where we presented a non-frivolous argument and he didn't address it.
But this, I mean, we do have the, let me ask the question instead of give a statement. So why doesn't his criminal history and repeated false statements sort of justified in this particular case?
Your Honor, I would say that if the district court tied those things together, that maybe that could be an argument. But here, that is what the district court did here was merely recite, as I'm reciting back to his PSR, I'm citing back to this, and didn't discuss each individual condition. And in Boyd, the same thing happened. In Boyd, this court recognized that the court discussed his criminal history and his priors, right? Almost all of the cases that are coming before you on these are 922Gs. So by definition, these defendants have prior crimes. And so the fact that he merely recites
These prior crimes are not, like, these prior crimes are specifically about giving false information.
Right, and the district court did not point to that. The district court pointed broadly to the PSR and to his prior criminal history and the serious nature of the 922G.
So he's got to go through and say, I'm talking about the PSR, but I need to go through and talk to you about this conviction and why it is that.
I think that he needs
That's
to.
your view. You got to go through them. You can't incorporate by reference, in other words.
I think that's, when Mr. Garris gave a specific objection, the district court needed to address that specific objection. For example, I find that the felon condition is appropriate here because you engaged in this conduct with another felon. So we're not asking a lot here. It could be one sentence where the district court actually ties Mr. Garris's history to the actual objection that he has made, and that didn't happen here. And so for that reason, we would argue that this court should remand.
And with respect to the supervised release issues, you want to remand as to all of them?
Your Honor,
Just the four you have identified?
No, Your Honor, my position is that as to all of the conditions, this court should remand because the district court failed to provide an explanation and/or failed to address any of Mr. Garris's non-frivolous arguments. And under this court's authority in Boyd and Comer and Van Donk and McMillan and Ross, that is just not sufficient. And the district court here did not do that, and it needs to be remanded for him to correct that omission.
Can I ask one final question, if I might, Judge? If we find one of them, so just pick a number, if we find one of them isn't adequately explained or is incorrect, doesn't that mean that we have to send the whole thing back and the judge has to do it again?
That's correct, Your
That's
Honor.
the sort of single sentence rule. And so you say you want them on all, but the real answer is all you need is one. And once you get one, then we can send it back and the court can take account of all the intervening case law.
Well, I would ask this court to be clear in its remand order that the district court can and should do that.
Isn't that sort of advisory, right? Because we've sort of said, once we say, you got this one wrong, like that means we have to vacate the entire sentence and send it back. Don't we then just say, like, we assume the court will take account of all intervening case law?
I would assume so, Your Honor, but I would say that in my experience, that has not always been the case in terms of looking at all of the supervised release conditions anew based on intervening authority. And so I would just ask that it be clear that that is the scope of the remand.
If we wanted to, we could affirm on the sentence, on the imprisonment, and vacate on the supervised relief issue.
Yes, I think that's
Is that
correct,
right?
Your Honor.
I mean,
Yes.
that wouldn't be vacating on the.
That's correct. I think that's correct, Your Honor. If there are no further questions, thank you very much.
Thank you all. Thank both of you very much. We appreciate your work and your help in these cases. And if we could do so, we'd come down and greet you and shake your hands. But we can't do it under the present circumstances. Maybe we'll do it next year. So